This presentation is brought to you by the law firm of McGowan & Markling. McGowan & Markling provides comprehensive legal services to public entities, officials, and employees throughout the state of Ohio. McGowan & Markling is very proud to remain among the select few law firms to consistently receive a Tier 1 ranking by U.S. News Best Lawyers, Best Law Firms in the areas of education, employment, and labor law, as well as the areas of municipal, labor, and employment litigation. As part of their ongoing commitment to the common good of Ohio's educational community, McGowan & Markling provides brief presentations on various issues facing educational leaders throughout the state of Ohio. If you would like to schedule a presentation tailored to the unique needs of your educational institution, please contact McGowan & Markling today. Our speaker today is Matt Markling. Matt is the motivating force behind McGowan & Markling's ongoing presence as a leading education law firm throughout the state of Ohio. Matt's wide-ranging experience and knowledge in education law makes him a preeminent attorney to advocate on behalf of Ohio's educational community. Matt's legal peers have consistently selected him as one of the best lawyers in America in the practice areas of education law, labor and employment litigation, and municipal litigation. Matt is also among the less than 1% of Ohio attorneys who have earned the prestigious distinction of being renowned as an Ohio State Bar Association certified specialist in labor and employment law. Matt is currently the superintendent of 2 island school districts, as well as a former elected school board president who has been bestowed with the lifetime distinction of Master Board Member by the Ohio School Boards Association, giving Matt a powerful perspective that has proven invaluable to Ohio's educational leaders. Welcome, Matt.
On behalf of McGowan & Markling, thank you for attending today's presentation. Please feel free to submit your questions in the comments section, and I will address your questions at the end of our presentation. For those of you who are viewing a recording of this presentation, please feel free to email me your questions at mmarkling@mcgowanmarkling.com. Today's presentation is entitled Good Day Sunshine, Public Records 101, and will focus on several basic public records aspects of the Ohio Sunshine Laws. Before we begin, let's address our legal disclaimer. Simply put, this presentation does not constitute legal advice. If legal advice is needed, please contact a McGowan & Markling attorney. Now that we have our legal disclaimer out of the way, let's discuss our agenda. We will begin our presentation focusing on general aspects of the Public Records Act and conclude by discussing additional available resources. Please note that links to these additional resources are available at the end of this presentation. In exploring the Public Records Act, we will first explain the necessary record limitation mandate, the 3-part test for defining a public record, and exemptions from this test. We will then address how public record requests may be made and how to respond to the same. And we will conclude by discussing other public record considerations. Let's begin by exploring the necessary record limitation mandate. Simply put, only necessary records can be created. Specifically, the head of each public office shall cause to be made only such records as are necessary for the adequate and proper documentation of the organization, functions, policies, decisions, procedures, and essential transactions of the agency, and for the protection of the legal and financial rights of the state and persons directly affected by the agency's activities. It is essential that only necessary records are created, as records are a crucial component of the government. They provide support for decisions made, explain government processes, and provide the public with the transparency that open government requires. Simply put, unnecessary records obstruct transparent governance. Now that we understand the necessary record limitation mandate, let's explore the 3-part test used to define a public record. Overall, the term record includes any document, device, or item, regardless of physical form or characteristic, including an electronic record, that is created or received by or coming under the jurisdiction of any public office, which serves to document the organization, functions, policies, decisions, procedures, operations, or other activities of the public office. Let's explore the first element of the three-part public record definition test. The first element focuses on a record, which is fairly broad, and as we just discussed, includes any document, device, or item, regardless of physical form or characteristic, including an electronic record. In other words, a record is something that contains information in a fixed form. It is important to note that the physical form of an item does not matter so long as it can record information. As you know, most public office information is stored on a reproducible fixed storage medium, such as paper documents, electronic documents, emails, videos, photographs, voicemail messages, and text messages. Unrecorded or not currently recorded information is not a record. For example, thoughts and unrecorded conversations are non-records. Now that we understand the first element of the three-part public record definition test, let's explore the second element. The second element focuses on a record that is created or received by or coming under the jurisdiction of any public office. It is usually clear when items are created or received by a public office, as the item is usually in the physical possession of the public office. Nonetheless, if records are held or created by another entity that is performing a public function for a public office, those records may be under the jurisdiction of the public office, and as a result, even if an item is not in the public office's physical possession, it may still be considered a record of that office. Now that we understand the second element of the three-part public record definition test, let's explore the third element. The third element focuses on a record which serves to document the organization, functions, policies, decisions, procedures, operations, or other activities of the office. If you take only one thing away from today's presentation, I want each of you to leave today knowing that it is the message or content, not the medium on which it exists, that makes a document a record for a public office. On the one hand, documents that may not document the activities of the public office may include junk mail and spam, home and personal addresses kept solely for administrative or management convenience, mailing lists, personal calendars and appointment books, proprietary software, and personal correspondence. On the other hand, the names and contact information of some vendors, contractors, customers, non-employees, and other third parties may document the activities of the public office. As a result, a case-by-case analysis must always be made to determine whether a record documents public office activities. It is important to note that an item received by a public office is not a record simply because the public office could use the item to carry out the duties and responsibilities of the public office. That being said, if the public office actually uses the item, it may thereby document the office's activities and become a record. For example, where a school board invited job applicants to send applications to a post office box, any applications received in that post office box will not become records of the office until the board actually retrieved, received, or otherwise used and relied upon them. By way of further example, personal, otherwise non-record correspondence that is actually used to document a decision to discipline a public employee does qualify as a record. As we previously discussed, a case-by-case analysis must always be made as to whether either the message or content of an item documents the organization, functions, policies, decisions, procedures, operations, or any other activities of the public office. Now that we understand the three-part public record definition test, let's explore exemptions to this test. While the Public Records Act presumes and favors public access to government records, Ohio and federal laws provide limited exemptions to protect certain records from mandatory release. If a record does not clearly fit into one of the exemptions listed in the Public Records Act and is not otherwise exempt from disclosure by other state or federal laws, it must be disclosed. There are two types of public record exemptions. On the one hand, there are those laws that mandate that a public office cannot release certain documents. On the other hand, there are those laws that allow the public office to choose whether to release certain documents. So how can we determine whether the exemption is either mandatory or discretionary? The test is whether there is a particular law that actually prohibits release of a record or just gives the public office the choice to withhold the record. If the law prohibits releasing the record, then the exemption is mandatory. If the law allows the public office to choose whether to release the record, then the exemption is discretionary. For our purposes today, we are going to assume that the following documents are mandatory exemptions. Personal privacy information, such as an individual's financial or medical information. Juvenile court records. Student records. Public safety and security records. Litigation preparation records and attorney-client privilege. Intellectual property, and other statutory examples found within state and federal laws. Now that we understand the three-part public record definition test and its exemptions, let's explore how public records may be requested. Simply put, any person can make a public record request for a record that actually exists at the time of the request and for any purpose. A requester may also specify whether the requester would like to either inspect the records or obtain copies. If the requester asks for copies, the requester has the right to choose the copy medium. The requester can choose to have the record copied on paper, in the same medium as the public office keeps them, or on any medium upon which the public office or person responsible for the public records determines the record can reasonably be duplicated. The public office may also charge the requester the actual cost of copies made and may require payment of copying costs in advance. Now that we understand how public records may be requested, let's explore how a public office must respond to such requests. To facilitate broader access to public records, the public office is required to organize and maintain public records in a manner that public records can be made available for inspection or copying in response to public records requests. It cannot be overstated that there is no set, predetermined time period for responding to a public records request. If the requester wants to inspect records, the records must be promptly prepared for inspection, which has been interpreted by the courts as being without delay and with reasonable speed. If the requester wants copies of records, the public office must produce the records in a reasonable period of time. The reasonableness of the response time depends on the facts and circumstances of the request. While these terms do not mean immediately or without a moment's delay, courts will find a violation of this requirement when an office cannot show that the response time was reasonable. So the time spent on response tasks will contribute to the calculation of what is prompt or reasonable in each circumstance. Now let's briefly discuss the response tasks. In response to a public records request, the public office must first promptly and reasonably identify all responsive records, which may involve seeking clarifications and revisions as appropriate. The public office must then locate and retrieve records from the storage location, whether a filing cabinet, computer, branch office, off-site storage facility, or the like. The public office must then review, analyze, and redact the records, which involves examining all materials for possible release, performing necessary legal reviews or consulting with knowledgeable parties, redacting exempt materials, and providing explanations and legal authority for all redactions and all denials. The public office must then prepare the records by obtaining the requester's choice of medium and making copies. The public office must finally either deliver the records upon advance payment for actual costs or schedule an inspection. Now that we understand how the public office must respond to public records requests, let's explore a few other public record considerations. Let's first discuss records management. Like other important government resources, records and the information they contain must be well managed to ensure accountability, efficiency, economy, and overall good government. As a result, the term records management encompasses two distinct obligations of a public office. First, in order to facilitate broader access to public records, a public office must organize and maintain the public records it keeps in a manner such that they can be made available for inspection or copying in response to a public records request. Second, a public office is prohibited from removing, destroying, mutilating, transferring, damaging, or disposing of any record or part of a record, except as provided by law or under the rules adopted by the Records Commissions pursuant to approved records retention schedules. In addition to managing records, a public office must create and adopt a policy for responding to public records requests. The Ohio Attorney General's Office has developed a model public records policy which may serve as a useful guide. In addition to managing records and adopting public record policies, all local and statewide elected government officials or their designees must also attend a 3-hour public records training program during each term of elected office the official serves, which can be taken either in person or online. The training must be developed and certified by the Ohio Attorney General's Office and presented by either the Ohio Attorney General's Office or an approved entity. And compliance with the training provision will be audited by the Auditor of State in the course of a regular financial audit. While this presentation provided helpful information on the Public Records Act, there are other excellent resources available to educational leaders. For example, the Ohio Attorney General recently issued a free publication entitled The 2023 Ohio Sunshine Laws, an Open Government Resource Manual. The Ohio Attorney General also provides online responses to frequently asked questions, online informational videos, and free online training. McGowan and Markling also provides updated legal blogs and school law newsletters, which you can subscribe to at mcgowanmarkling.com. Our school law hotline is another valuable resource for educational leaders. As part of our ongoing commitment to the common good of Ohio's education community, McGowan and Markling offers all eligible Ohio educational institutions with 5 hours of pro bono legal services per calendar year through our exclusive school law hotline. As a result of this commitment, the Ohio Supreme Court and Ohio Access to Justice Foundation have recognized McGowan and Markling as providing the most pro bono hours per attorney than any other law firm in Ohio. It should be noted that there is a significant distinction between the school law hotline and any access that you may receive from the legal division of the Ohio School Boards Association. While the OSBA Legal Division may provide you with legal information and resources, the OSBA Legal Division will make it clear to you that they do not represent school districts or render legal advice to districts. That is not the case with the school law hotline. By participating in the school law hotline, McGowan and Markling attorneys are both representing your board and rendering legal advice to your board. To learn more about the school law hotline, please visit schoollawhotline.com. On behalf of McGowan and Markling, thank you again for attending today's presentation. Our next presentation is entitled Not All Heroes Wear Capes, School Board Members 101, and will focus on several basic roles and responsibilities of school board members. If you would like for McGowan and Markling to provide you with a presentation tailored to the unique needs of your educational institution, please contact McGowan and Markling today.